Good morning, everyone, and you're very welcome this morning to our webinar on commercial contracts, what's market. My name is Edel Hartog, and I'm a partner in the commercial contracts team in MHC. I'm joined this morning by my colleague Wendy Hederman, also a partner in our commercial contracts team. Across our practice, Wendy and I advise on a broad spectrum of commercial contracts for public and private sector clients and across a range of industries. And this morning we're going to discuss with you our experience of what we're seeing as what's market in some very common or key contractual issues that our clients are coming across. By what's market we mean what's typical or usual or standard practice that we are seeing in the contracts that we are drafting and negotiating. We are of course conscious that every contract and every circumstance deserves its own bespoke attention. And it may not be appropriate in a given case to apply a standard market or market-defined approach. But what we have seen useful in advising our in-house counsel clients, and certainly for us as drafters and negotiators of commercial contracts, is that it's often very helpful to have a barometer or a benchmark of what's normal or what's standard or what the typical contracting approach in a given issue in a contract will be. And often that's helpful in things like liability caps and indemnities. So this morning, by sharing our experience and the data we have with you, we're hoping to give you, I suppose, an evidence-based tool to support you in your own negotiations. And I suppose to give you a response when you're met with that very common phrase in negotiations, your position is off market or that's not market. Before I hand over to Wendy, I'll mention very briefly that you're very welcome to ask any questions during the course of the webinar. Please put them in the Q&A box at the end of your screen. We'll compile these and we'll get to them at the end and we'll take as many questions as we can. Wendy, over to you.
Thanks, Edel. Yes, for the past few years in the MHC contracts team, we've been tracking the main clauses in a wide range of contracts, whether it's a software license or a framework purchase agreement, a distribution agreement, or an outsourcing. There are a handful of clauses found across all these contract types that most often give rise to the trickiest negotiations. And we've been compiling a database of these common legal clauses so that we can keep track of what's been agreed in particular transactions, and so we have a bank of clauses to deal with particular circumstances. And also it's allowed us to spot trends in how these issues are tackled in practice. And we call that our MHC What's Market tracker. And it means that we can advise clients when they ask us whether it's reasonable that they refuse to give an indemnity for X, or, you know, what's the usual position in Ireland on caps on Y type of liability. So we decided that it'd be very useful to complement that MHC tracker with a survey of in-house counsel. So, and asking you what your experience and your practice was, so that we could sort of throw the net wider on spotting trends and establishing with more accuracy what's market standard. Thank you to all of you who responded. We really appreciate you taking the time to work through our questions. And we're today going to share with you the results of that survey, along with some more detail from our own tracker. So the topics we're going to look at today are particularly liability. You know, what types of cap, the size, the level of caps, and also carve-outs from the caps or special cases, super caps. We're going to look then at indemnities and turn to a few particularly topical issues, sort of force majeure in the COVID-19 context, and Brexit, good faith obligations, and finishing up with e-signatures. So Edel, could I ask you to tell us a bit more about who responded to our survey?
Absolutely, thanks Wendy. So I think you'll find, or certainly we're finding, the results of the What's Market survey really interesting. And we've taken 3 data points in the survey. The first of these, and which you'll see mostly today in our data sharing, is a B2B supplier customer approach. So you'll see that just over the majority, about 57% of our respondents identified as suppliers and 43% as customers. We looked also at 2 other data points. This middle here is which industry best describes you. And you'll see, for example, a different response across the industries. So 34%, for example, responded from the technology sector. And what that usefully has allowed us to do is to, as Wendy said, spot the trend across industries and how they're adopting different approaches in their contracts. You see later, for example, that for e-signatures, what we saw in the data was the most common uptakers, as it were, of e-signatures were those in the technology, telecoms, and other utilities industries. The final data point is the split between public and private sector. And you'll see here that the majority, just over 81% of our respondents, responded from the private sector. I think that's in part because public sector entities who are subject to the public procurement rules will typically contract using the OGP standard template form of contracts. So the consultancy services contract, etc. What that means is that certainly the plan of the OGP is that there will be a more consistent approach across public sector entities in how they approach their commercial contract standard positions. We'll come back to both of these last two data points, I think, more later in the year as we continue to do our data mining. But this morning we're going to concentrate on B2B supplier customer responses. So if I turn then to the first issue, and those are liability issues. And as we all know, liability caps and the quantum of liability tends to be the most controversial or tricky and contentious issue in drafting negotiations. Our experience is that it's very unusual for a contract these days not to have some form of liability cap in them. You know, the exception may be the first draft of a contract generated by a customer, but very often, typically, a liability cap will be negotiated at subsequent stages of the negotiation. The data bears this out. We asked our respondents in the survey, do you routinely include liability caps in your commercial contracts? And you'll see here overwhelmingly, over 100% of suppliers and over 80% of customers indicated that they routinely include either a mutual cap or a cap for their own interests in their routine commercial contracting approach. Interesting, in the survey, you start now to see the diverging interests of customers and suppliers. We asked which of the following approaches to caps do you most commonly apply? In other words, how do you cast them? How do you frame them? And suppliers responded by saying their preferred approach was either a cap at the total contract value or a cap at the annual fee. Now, these figures add up to more than 100 because our respondents could answer more than one, but you see the preferred approach of suppliers was cap at the total value or the annual fee. Customers, in contrary, preferred, for example, 48% of them preferred to cap at a percentage greater than the contract value or to cap it at the total contract value. And that's not unsurprising. Naturally, customers are going to approach this with a view to ensuring that their liability is insulated by having a liability cap that is of a percentage greater than the contract value. In terms then of what those multiples are, or how large the liability cap is, you'll see a consistent approach between suppliers and customers. 70% of suppliers and 60% of customers indicated that they preferred a liability cap of 1 to 2 times or 100 to 200% of the total contract value. And certainly that's the norm that Wendy and I are seeing in our practice as well. Usually your cap is around the 150 to 200% of the contract value. Now that will vary, and again, it depends on case by case, industry to industry. While you rarely see higher multiples, you may see them, for example, if the monetary value of the contract is relatively low, but nevertheless, the importance of the contract to the business or the damage to the business from a breach of that contract could be disproportionately higher. So you may have different or higher multiples in that scenario. You'll also likely have higher multiples for special or sensitive cases, and you often refer to these as super caps. And Wendy, I'll hand over to you to have a look at the data on those.
Yeah, thank you, Edel. I think what we have seen, particularly on this area coming through from the survey, is that it's not a case of one cap fits all. There's a more layered, more nuanced approach to caps.
Yeah.
Our question to you, do we have the next slide, is do you apply a separate cap, lower, higher, or uncapped for any of the following? And we show the data by 6 different types of breach or damage and split by supplier and by customer. So that's giving us a lot of data points, and I'll take you through the slide. So as before, the blue bars represent supplier answers and the green bars are customers. So working from the left, the first type of damage or breach we asked about was data protection. The next one is breach of confidentiality. And so actually, let me stop there where I have a red ring. You can see from that the survey results are that for suppliers, in blue, 12% of the time, the supplier would apply a lower cap than the standard contract cap, which Edel was talking about, when it comes to a breach of confidentiality. 37% of the time, the supplier would expect the cap and confidentiality to be higher than the standard cap, and 75% of the time they'd give uncapped liability for breach of confidentiality. And like with Edel, it adds up to more than 100% because you could answer more than one. And so take these as sort of orders of magnitude relative to each other. Similarly, moving across to the next red ring, third-party IP breaches, suppliers, 72% of the time prepared to consider giving uncapped liability. And in the green bar beside it, customers would expect 94% of the time to get an uncapped liability for IP breaches. I marked also there property damage, where it seems that suppliers would give a lower cap. That's 78% into getting a lower cap on liability. And certainly our Maisonnaise database would show that in particular circumstances where perhaps outsourced services agreement, or where there's a supplier would have the ability to damage equipment or premises of the customer, that the customer would expect a reasonably high liability on property damage, particularly as this can be covered by the supplier of the defendant's insurance policy if they were to reverse a truck into the back of the factory or whatever. So what I do in the next slide is to separate out this data by supplier on the left and customer on the right. And in this instance, we've had to change the colouring bit so that the yellow is showing uncapped liability. You can see that in the chart on the right hand side, the customer responses have indicated that for DP, breach of confidentiality, third-party IP breaches, and the next three, defective products, property damage, and indemnities generally, a majority of them will be looking for uncapped liability. Where back on the supplier side, on the left-hand side, they were prepared to give a higher or uncapped liability for just three areas: data protection, confidentiality, and IP or breach, but not for the subsequent three. So we drilled in also, we then asked a separate question, a follow-on question regarding GDPR liability, because this has been a particular battleground over the last 2 to 3 years. And on the next slide, we will see that the question we asked was, do you concede or will you ask for uncapped liability for GDPR breaches? And just under a third of suppliers indicated they would accept uncapped liability. And just note in the graph on the left-hand side, the numbers. So actually those three bar charts are in similar order of magnitude. 31% of suppliers saying they'd accept uncapped liability. The others won't give uncapped liability, but half of those others would accept a higher cap. So that's in the bar there, 32%. From the customer perspective, higher proportion say they will always, 34%, or in special or sensitive cases, insist on uncapped liability. We also drilled into this data by sectors, not here on the screen, but we looked at it for financial services, professional services, and technology. And in the technology sector responses, 33%, a third, answered that they would stick with the standard cap. No special treatment, no exceptions for GDPR liability, it would be the standard cap. But about 42% answered that they would concede a higher cap for GDPR liability, and a minority, just 25%, said they would agree uncapped liability. Now, I have to say from our experience of contracts, it can be pretty hard to get suppliers to agree uncapped liability, and there's a real nervousness around, the extent of damage that could be done, or the sort of sensitivity of data, and that suppliers don't necessarily think that all of that risk should shift to them. So we do see a reluctance on uncapped liability, but particularly in negotiated cases, and particularly where a client, flags early on in the process that data is going to be a big issue for them, we've seen that caps of 7.5 million, 13 million, even 20 million for GDPR liability have been given. So I think before we leave this whole topic, it's evident that a more sort of layered, nuanced approach is taken to caps. It's rare that you'd have in a B2B contract, that you just have one cap applying to anything and everything. There is a difference in expectation from the customer and the supplier side. A lot of commonality, common ground on what the liability for confidentiality, IP breaches, and also fraud and misrep, which we didn't actually ask about in the survey, but there's a divergence in the other issues we outlined. GDPR liability, the battle lines are still developing, so let's watch this space. And finally, our experience is where contract caps or liability is going to be a big sticking issue. And if you're not going to get board approval for your particular transaction without having, say, a minimum of 10 million liability on IP breaches, well then set out that stall early. Okay, I think we'll turn then to indemnities. Indemnities, another area can be really tricky in negotiations, and we have found that there's a fair degree of consistency in the survey data on what indemnities are likely to be in a B2B contract. In the survey, we asked you what indemnities you usually give or expect to get in a B2B contract. And you can see from this slide that the most commonly given or sought indemnities are breach of third party IPR rights, that block at 95% there in green, the second one. GDPR data protection subject access claims there in the left-hand side, 43%, 70%, so an average of about 55%. And then death or personal injury caused by negligence. They're the most common types of indemnity included in your B2B contracts. There's also transfer of undertakings, 2P, comes up reasonably often. It's probably limited in number because not all types of B2B contract actually give rise to 2P issues. A straightforward just sale of goods isn't going to need 2P indemnities. One of the respondents pointed out that they would expect to give a 2P indemnity on exit, but they will be looking to be given a 2P indemnity on entry on the start of the contract. And yeah, that's absolutely fair, and that aligns with our experience. You can see from that slide that there's a fair bit of consistency between the supplier and the customer responses. There's just one where the suppliers indicate they're prepared to give indemnity for greater amount of times, and customers say they're looking for it, and that's in the personal injury caused by negligence. So our learnings on this, I suppose, thinking particularly that an indemnity, it's a promise by one party to pay money to another, to reimburse on a euro for euro basis the other party for money that is lost or paid out. And it's the trigger event that's really important in an indemnity. How is it triggered? Is it by a third party claim? Is it just by losses occurring? It's not the same as a contract breach, though often in B2B contracts, indemnities are drafted as a remedy when one party has breached the contract. But the wording of the indemnity clause is key in all of this. And we know from the UK case there relatively recently in 2017 of Woods and Capital Insurance that the courts will take a very forensic approach to the wording in the context of the overall contract. And if you want particular types of damage to be recoverable, then you need to say it in your contract. Because the usual or all of the rules that apply to breach of contract and damages don't necessarily apply to indemnities. But also when you're drafting your indemnity or your indemnity clause, do pay attention to how it interacts with the caps. They're not the same thing. Do you repeat your caps in the indemnity clause? Do you put a separate cap? Do you leave it to anybody's guess as whether it's capped or not? So I think we'll move on to the next topic was force majeure, if you wouldn't mind, Edel.
Thanks, Wendy. So I suppose on force majeure, it's one of those areas that up until very recently was commonly considered as a boilerplate or part of the general architecture of a contract, but didn't get a huge amount of attention. Naturally, during COVID-19, that has changed hugely. And a lot of us are looking at force majeure clauses and forensically assessing whether COVID-19, for example, or the restrictions on movement resulting from COVID-19 can be accommodated in a particular force majeure clause. So suppliers, for example, are looking to see whether they can seek relief from performance, and customers are looking to see whether they ought or must give that relief when they're being asked for it. And certainly that approach is being borne out in the data that we're seeing. We asked our respondents, does your current standard force majeure clause specify a pandemic or epidemic or like spread of disease category as a force majeure relief item? And you'll see the responses is pretty consistent between suppliers and customers. 43% have said, yes, we already cater for this in our force majeure boilerplate clauses. And I think part of the reason for that is probably legacy reasons. COVID-19 isn't the first instance where we've had a national restriction of movement of the type that we're having with COVID-19. In 2001, for example, we had the foot and mouth crisis, and in 2002, 2004, we had the international SARS epidemic. So we may have seen those, for example, affecting the legacy drafting of some of those force majeure clauses to the benefit now, where they're being triggered during COVID-19. For those respondents who said they don't currently expressly provide for it, we asked, do you intend including such a provision in your contracts in the future in light of your experience with COVID-19? And 56% of customers said yes, and 37% of suppliers said yes. So this is certainly a trend we're also seeing. We're seeing a shift in our practice to certainly a more forensic analysis of, is this force majeure clause bespoke? Is it fit for purpose for this particular contract, given a possible either re-emergence of COVID or re-emergence of a COVID type event in the future? The data on this is interesting. We asked, have you had to consider seeking or granting relief under a force majeure clause in recent weeks in light of the COVID-19 restrictions? Now, from the suppliers, 78% said no, but interestingly, our customer respondents indicated 65% of them had been approached and asked for some type of relief by their suppliers because of the COVID-19 restrictions itself or the restrictions flowing from it, for example, the restrictions of movement. 40% of our customers indicated that yes, they had provided some form of relief, either in the form, for example, of extension of time, temporary suspension of performance obligations, or interestingly, an additional contribution to the supplier's costs arising from the COVID-19 circumstances. So interesting that we're seeing a very live use of force majeure clause during COVID-19 circumstances. So this is, what does this mean for going forward and for our practice? Well, case law has very clearly established that there is no settled or defined legal meaning in Irish or UK law of the term force majeure. And so our ability to rely on a force majeure clause will turn on the exact four walls of that clause and how we describe or define what a force majeure item is. The ability to rely will also turn on, I suppose, the ability to demonstrate that non-performance in a given case is due to the force majeure event. So we know and we're seeing, and certainly as lawyers, Wendy and I are very conscious of the fact that the drafting of the force majeure clause is very critical. We are seeing in our practice a huge range of drafting of force majeure, and much of that will turn on, for example, what's public sector precedent, what's private sector precedent, what typical approach does a private technology company use in its standard contracting arrangements. But the language we are seeing is varying. So we see, for example, high standard in cases that say performance must have been prevented by the force majeure event. And in others, either or, we see words used such as performance must have been hindered or delayed by the force majeure event, which certainly is a more generous standard to one which says it must necessarily have been prevented. I mentioned on the screen, solely for illustration, the case of Classic Maritime. It's a 2019 UK case. And in that case, the court was willing to do a surgical or forensic analysis of the wording of the exclusion clause or the force majeure clause in that case. And in that case, the force majeure clause in a charter party contract indicated that performance would be excused for failure to deliver resulting from a specified event which directly affected performance. And the court looked at that clause, which was in dispute as to what it meant, and it read into the clause a but-for test. So it said, the wording of this clause, as it was drafted, meant, but for the force majeure event, performance would have been delivered. So we're seeing then the courts reading into particular clauses and that these issues are being litigated. And certainly our projection is that over the next few years, we are likely to have COVID-19 cases being litigated before the courts, where particular clauses are being looked at and the courts would be called on to interpret the wording that is used. So what this means, I suppose, so what's market for force majeure? I think the answer obviously is that many of us are now adapting our contracts and looking more carefully at how we're crafting these clauses and what triggers them and what's the process for triggering them in order for clients to get relief. The trend I think we're seeing is definitely that there will be a more frequent examination and negotiation of these clauses going forward. And I think it certainly is moving out of the boilerplate realm to certainly one of those clauses that is on the forefront of our mind when we are negotiating our contracts.
There, Edel, I may say before you finish this, that force majeure clauses, we were looking at them in the particular circumstances of COVID in Ireland. It wasn't necessarily epidemic or pandemic that needed to be named in the clause.
Yeah.
It called out government regulation, order of public authority, etc. Because for a lot of suppliers and companies in Ireland, it wasn't the pandemic itself, it was all of the restrictions that were put in around it, the 2 kilometre limit, the ban on travel and export, etc. So, force majeure clauses, there can be a lot in them that you need to work through to see does it apply or can be used in particular circumstances.
Yeah, exactly. So turning then to Brexit, is it still relevant to our commercial contracting arrangements? I suppose to give you a very brief recap, the UK has left the European Union and is currently in a transition period until the end of this year. The UK Brexit negotiators have strongly indicated that they do not envisage the transition period being extended beyond 31 December 2020. And what that means is that from the 1st of January 2021, the UK will not be a member of the European Union and will not be obliged to adhere to EU law. So we can possibly have a divergence of UK and Irish and EU law from January next year. So I think certainly COVID-19 has dominated our attention in the first half of the year, but Brexit is very likely to be the sleeping giant. And I think we're going to see more of it, and more of it in relevance to commercial contracts as we get towards the end of this year. So is it still relevant? Certainly yes, in our practice it is. And we apply Brexit as a sieve or a filter, or as part of the things that we look at. Or we're looking at contracts that are either governed by UK law or have a touch point with the UK in terms, for example, of transfer of data or people or goods or services in and out of Northern Ireland or from Ireland to the UK, for example. And the data from the survey bears this out. We asked our respondents, in your contracting arrangements, how often is Brexit a consideration for your organisation? And you'll see that 69% of customers and 35% of suppliers said that yes, sometimes it was a consideration. And actually the data points on this will flex depending on whether the respondents have international contracting counterparties, for example. We asked that when contracting with international counterparts, how would you approach a contract governed by the laws of England and Wales? And I think the response here is very interesting and it's indicative of a trend that we are seeing. 55% of customers indicated that they would insist on Irish law and jurisdiction instead of the laws of England and Wales. And you'll see a smaller percentage, 22% of suppliers indicated that. I think what that's showing is certainly a preference by Irish Law Council or Irish Council to insist or mandate that the contracts with their counterparties are governed by the laws of Ireland. Whereas probably in the past, we may have been more flexible or more relaxed about accepting UK law, for example, if there was a disparity of bargaining power, because we were relatively comfortable that the laws were pretty aligned between Ireland and England. So I think we're seeing a trend here of pushing away from UK law. So what does this mean? So what? I suppose the case law on the UK on this has already established that Brexit is generally not, or is not by itself, a frustration event. And by that I mean that the parties to a contract will not automatically be relieved from the unforeseeable circumstances of Brexit. The contract mechanics themselves have to future-proof for Brexit or provide for what we think will happen in the event that Brexit impacts on the delivery or performance under a contract. So when we're looking at contracts that have a touch point with UK, we look at a number of factors, and I'll mention some very briefly. The first of these, or the obvious one, is data protection. We do envisage, or it is envisaged, that the UK will get a data adequacy finding from the European Commission. And what that will mean is that data will be capable of transferring freely between Ireland, Northern Ireland, and the UK. But I think at this point of the negotiations, or certainly where they are in terms of where they'll be by 1 January, I think it's likely that there's going to be a gap and there won't be an adequacy finding by 1 January 2020. So what that means is that there certainly will, from 1 January 2020, potentially be a transfer of data from an Irish entity to a non-EU or EEA entity. And so we may need to have some workarounds for the interim or the gap. So for example, standard contractual clauses. We also need to consider other issues like TUPE. So for example, if you have an outsourcing agreement or an arrangement where TUPE will be a relevant consideration on entry or exit of the contract, then we need to consider, what is the UK going to do with TUPE? Could it change its laws? Could it disapply its TUPE regime? What happens in the future if we have a contract governed by UK law where a TUPE event that ordinarily would be subject to Irish and EU law would arise? We also will have other issues such as compliance with law or change in law obligations. So if in the future Irish and UK law diverge and there is for example, an increased or decreased standard between them, who bears the cost of the higher or lower burden of compliance? If there's a cost because of change in law, who bears the cost of the change in law circumstances during the currency of the contract? Other practical issues will also apply. What happens if there's delays arising from customs or border controls checks? What happens if there's sterling fluctuations? What happens, for example, in an innovation or assignment scenario if an EU headquartered entity decides to move the headquarters to another EU member state arising from experience from Brexit? I think the elephant in the room naturally also is, how will we approach the contractual enforcement of contracts? So for example, how will there be mutual recognition of judgments if, for example, the UK does not sign up to the Rome Conventions or the Brussels Recast Convention or the Lugano Convention? And the final point I mention here is, naturally there are differences between Irish and English law, and we are seeing that in our practice. I think, Wendy, you were going to talk to that point.
Yeah, certainly in the last 12 to 18 months, I've had more queries about the differences or similarities between Irish and UK law than ever before, because I think quite a few UK companies are probably getting pressure from EU-wide customers to move away from because those customers aren't prepared to have English law as governing law anymore. Yeah. So Irish has been considered as the alternative. And there are, a lot of similarities, but also to be aware of the differences between Irish and English law.
Yeah, we are both seeing that, I think. So in summary, what's market for Brexit? Yes, it is still a relevant consideration. The trend we're seeing is probably against accepting UK law jurisdiction in contracts where they have one or more EU counterparties. Where that's not possible, there's certainly an adaptation of contracts for specific issues that Brexit can touch on, like data protection, compliance with law, currency, and tax issues. I'll hand back to you, Wendy, on good faith obligations.
Okay, good faith. Well, what we have seen is that the majority of your contracts are ahead of the courts, the Irish courts, on good faith obligations. I mean, we asked you this question because the law in Ireland and the UK has been sort of shifting on this topic in recent years, and it is something that's worth paying careful attention to in our B2B contracts, particularly long-term framework contracts. So looking first at the survey results, 70% of our respondents indicated that yes, they do include good faith obligations in B2B contracts. On the supplier side, they're more likely to limit the good faith obligations to specific circumstances or only where the good faith obligation is mutual. On the customer side, they favour it being included generally, about 45%, or in specific circumstances. And I have to say those levels are higher than I expected, but perhaps as we sort of work through what sort of specific circumstances good faith may arise in, that the reasons for this might become clearer. I mean, looking briefly, at the moment there is no implied duty of good faith in Irish law. Good faith will only apply in a contract where there is an express provision. I mean, contrast that with civil law jurisdictions where there's generally an obligation of good faith, arising in the French and the Swiss civil codes, and even understand it in the US, the Uniform Commercial Code provides that every contract or duty within this act imposes an obligation of good faith in its performance or enforcement, and that provision cannot be waived by the parties. Whereas in the UK and Ireland, traditionally, duty of good faith was not implied by the courts, a notable exception being in the commercial agents regulations, which of course is EU-based law, where the obligation of good faith on both the agent and the principal in their dealings with each other. I mean, Ireland, the Irish courts have toyed with the idea of implied obligation of good faith. We know that in the Flynn and Berkia, the High Court sort of went one way, but then the Court of Appeal held that the Irish contract law does not recognise a general principle of good faith and fair dealing. But the judgments of the court in that case have left open the possibility that a duty of good faith could be implied in certain circumstances. So it is a watch this space. And in the UK, the position, as I say, has been shifting. And you can see that most definitely in last year's High Court decision of Bates versus the Post Office, which found that there was an implied duty of good faith and fair dealing on the part of the Post Office because this was a relational contract. And very briefly, that case related to about 550 sub-postmasters who sued the Post Office, mostly arising out of problems with the implementation of a new IT financial management system called Horizon that had big problems with it. And in the Bates case, the English High Court found that this concept of a relational contract is an established one in English law. And it brought with it an implied obligation of good faith and fair dealing. And the court determined or set out an indicative list of criteria as how you determine what's a relational contract. Firstly, there mustn't be any express term in the contract that prevents a duty of good faith being applied. A relational contract be one which is a long-term, has the mutual intention of long-term sort of collaboration. The contract would involve a high degree of communication, cooperation, predictable performance based on mutual trust and confidence. And in any event, in that instance, finding applied duty of good faith resulted in about 14 or 17 further obligations on the Post Office, which was very helpful to the plaintiffs. But the Irish position is as under Flynn. And so that represents the current Irish position that there is no duty of good faith, but uncertainty will continue until the Supreme Court delivers a definitive judgment, and it may well arise in cases that come up in the next few years. So in the meantime, if parties want to ensure that good faith arises in their contracts or in particular circumstances, or if they want to ensure that good faith is not implied, they need to cover this specifically with the use of bespoke language in the contract. And what would, move the next slide, what does good faith mean? In the Bates case, it was considered that it does no more than require a party to refrain from conduct, which in the context would be regarded as commercially unacceptable by reasonable and honest people. I mean, in other cases, it's taken to mean acting honestly. You might move on to the next slide. Acting honestly, being loyal to the bargain, not taking unfair advantage over the other party. And I think we will see the inclusion of expressly defined good faith clauses in more commercial contracts in Ireland. And I think also attention being paid to specific circumstances which are called out for where good faith will apply. For example, in the parties dealing with external circumstances, or dealing with a change of scope in the contract, or unexpected costs or external factors that the parties may be obliged to sort of negotiate in good faith on them, or consider and act reasonably in relation to those sort of unexpected circumstances arising.
Yeah, Wendy, I think on that point as well, I'm with you on that. If what we're saying is that there's no implied duty of good faith in Irish law at the moment, and queer whether it's coming, I think what we're probably seeing is some of it coming in the back door. I mean, certainly what I'm seeing, definitely in public sector contracts, is this refrain of the parties must, acting reasonably, exercise their discretion, or acting reasonably, give consent in a given case. The question whether that's kind of imputing these good faith obligations through the back door, and whether these good faith case laws are relevant to interpreting what a duty of a counterparty is when they must act reasonably. So I definitely think this is an interesting one to watch in terms of how we craft our contracts.
And then often that negotiation on acting reasonably, when somebody refuses to have it in, the counterparty goes, so you're intending to act unreasonably when I come and ask a change in X. And the same sort of thing arises when you're negotiating good faith obligations if they're not mutual. You know, the counterparty is going to go, so you're actually intending to act in bad faith. So, you know, really need to watch if you are going to look for an obligation of good faith on the counterparty, you need to be prepared that question to be put back to you going, well, are you going to act in good faith towards us? So, so that brings us to, I think, our final topic for today, e-signatures, Edel.
Yes, absolutely. And I think it would have been remiss of us not to have a commercial contracts topic during the COVID-19 circumstances that didn't talk about e-signatures. And look, I mean, we'll be very brief on this. You know, e-signatures, we are seeing a huge evolution or take up in practice during the COVID-19 circumstances. And that's certainly borne out by the data that we're seeing in our survey. You'll see here from suppliers and customers, nearly 82% of suppliers say they always or sometimes use electronic signatures, and 90% of customers say they would sometimes or always use electronic signatures. I think that's a very interesting data point in terms of how prevalent electronic signatures have started to become in the market. When we asked our respondents what type of electronic signature they would accept in a transaction, you'll see here, and they could select more than one. You see the preference is for scanned handwritten signature. You see 70% of suppliers and 55% of customers, or a higher preference certainly for signatures using a third-party document signing platform like DocuSign or Adobe Sign. 83% of suppliers use it and 80% of customers use it. And we're starting to see that as well in MHC practice, this greater take-up of DocuSign or the like when we're having virtual closings or signing of contracts. I won't go into any detail of the law of e-signatures. We in MHC had a webinar on this about 2 weeks ago on virtual completions and e-signatures, and I put the link here to the recording for your benefit. But what I will say in summary is that the law on e-signatures has not changed recently or during COVID-19, but legal practice has, and it's certainly evolved. This has been moved in part by the Law Society of Ireland's guidance note on e-signatures that was published in March this year. And I think, you know, that guidance note, together with COVID-19, has certainly pushed us more away from that distrust of electronic signatures to a point where we think it's probably going to be more the norm now, post-COVID, like Zoom calls, I suppose. But what I will say in terms of a learning from a commercial contracts perspective is that the law says that for most contracts and legal documents, with some exceptions, a simple electronic signature can be used provided both parties consent. And consent can be expressed or implied, but certainly our recommendation and best practice is that you hardwire that consent into your contract. So you adapt, for example, now the boilerplate provisions of your contracts to include an acceptance by the parties that the contract may be executed electronically in counterparts or via various signing platforms. I mentioned briefly, e-signatures is not an unbumpy road. There are many roadblocks that we are coming across in practice, particularly in the area of sealing and witnessing. I think the law on this will certainly evolve, but there are tricky issues that are encountered. If I were to summarize this to, I suppose, what's market on e-signatures, I'd say the market practice on this is evolving hugely in Ireland and the UK. We know from data in the UK that Ireland isn't that far behind. The UK also has seen a recent spike in take-up of electronic signatures. So again, we see law firms and legal practice moving towards now the more, I suppose, trusting acceptance of the use of e-signatures. If I were to discern a trend, I'd say it's probably more a shift towards the use of e-signing platforms because of the extra security and encryption and audit trails that they can provide. What we're also seeing is a trend towards the use of what's known as two-factor authentication. And so this applies that where you're using a document signing platform, you will be challenged to verify your identity, not only by signing in via your username and password or email address, but also by providing a unique identifier, for example, a PIN code that has been texted to you via SMS. So this is no different to what we've been doing for electronic banking for many years. And we're still seeing that now start to permeate the execution of commercial contracts, where we're seeing law firms, and particularly certainly MHC, looking for a two-factor authentication approach when platforms like DocuSign or Adobe Sign are being used. So moving then to the key takeaways, and we've put here on over 2 slides some graphs summarizing, the key data points or the salient points of our findings from the survey and our own experience with the MHC tracker. We won't go into any detail on these, and there's lots of data behind them that we in MHC are using and will continue to mine. And we'll publish more on these areas later in the year. But I think what it might be more useful to do now, Wendy, is to have a look and see, are there any questions and whether we should take any questions at this point.
Okay, well, yes, I was keeping an eye on questions that came in. The first two that are in fairly promptly were on liability caps for data protection, and one question saying experience very mixed responses from software vendors. And I think we've probably covered that as regards the different expectations and range of responses from suppliers, and as well as giving a little bit of the data by sector. And another question coming in regarding shouldn't a data processor be expected to take on uncapped liability for data which they process or they control, where that's, you know, outside of the control of the controller, that it doesn't happen in practice, but what will be the position if it actually got to court? And I think there is really interesting interaction both between the contract clauses and also the provisions within GDPR itself, like Article 28.3, data processing agreements. And I've come up against the argument that from certain parties, particularly in continental Europe, that say that GDPR doesn't allow a party to cap its liability. I don't think in Mason Hayes our view is as strict as that a data processor cannot cap its liability. I think in a B2B contract, you know, an allocation of risk between them is allowed. But I think what's indicative from those questions is that the battle lines are still being drawn. I think there's, you know, going to be need to be some of this teased out in the courts and possibly even in the ECJ before we get to a very definitive position on position of liability caps for data protection breaches. There's another one here we might just briefly answer on Brexit. Do you see it as a material business risk for a supplier or customer not to have Brexit proofed their contracts? I think, Edel, that's probably for you.
Yeah, I might take that one. I think potentially, in the sense that if your contract has a touch point with the UK, and if you have, I suppose, you know, there's referred to as the four fundamental EU freedoms, the freedom of movement of goods, services, people, and capital. And you might add data to that. So if your contract has these things moving in and out of the UK, then the fact that your contract might be silent on Brexit could potentially give you issues in the future, where you have a divergence of laws or a change of laws, or we have practical roadblocks. And I think the first couple of years of a true Brexit event, we will see practical issues with delays in getting goods into Northern Ireland, for example, or across the border, or delays in getting people's residency recognised in different countries. So yes, in principle, it can be, but again, it depends on the materiality of the touch point between your contract and, you know, the UK in a given case.
Okay, we have now a little flood of questions and we are quite tight in time, so I'll take a few that we can answer very briefly. Asking for us to go into more detail on liability caps and how this interacts with indemnity. My experience is that it depends very much on how both the liability cap clause and the indemnity clause are worded, whether one expressly refers across to the other, or whether, for example, your liability cap is worded broadly enough to say, you know, for any and all liabilities arising on howsoever arising under this contract or howsoever arising between the parties. That's probably broad enough to cover liabilities under indemnity. But if your indemnity clause is something as, you know, indemnify for in full for all loss and damage, howsoever suffered, blah, blah, arguably that wording is outside that of a cap. So be very careful in how both of those clauses are worded and think about how they interact. There's no automatic rule. Also, a quick question on the indemnities and the interpretation of the UK Supreme Court. It was a case of Woods from 2017, and I'll see if I can find that or include it in the slides so that you have that detail. We've been asked, can we circulate the slides and a link to replay the webinar? I think certainly a certain amount, whether the full slides or the majority of it will be available to those on this call afterwards. Edel, any questions there that catch your attention that we're probably a little bit out of time?
Let me see, I think we're probably coming up out of time, so we might wrap up there, Wendy. And so I suppose it leaves it to us for Wendy and I to say thank you very much this morning for attending our webinar. Our details are on the screen. We will, if there were questions that we didn't get to, try insofar as we can to contact you directly and respond to you. Thank you very much and good morning.
Thanks a lot.